Hello, everybody. Thank you for joining us this morning. And we'll be covering how to use non-disclosure agreements and how they relate to developing teaming arrangements for federal, state, and local government entities when you're doing business with them. And just in doing business in general. Uh, NDAs are encouraged, okay? If you're in business and you're competing with other companies for work and, working with other companies, you want to protect your company's proprietary information and, information that you're sharing from company to company. Okay, so let's get started. Here's just a little bit about me. Um, for those of you who haven't taken one of my classes in the past, I've been in federal contracting pretty much all of my career. As I got out of college, I started in federal business at an 8A firm that grew, wow, to really over wow, about 100 million per year. And I've that's where I got my expertise. And now I'm doing consulting and helping people navigate the federal government workplace. So just, kind of read about me at your leisure. So, initially I just like to say, like I mentioned earlier, that if you're in business, you should be protecting your company, especially in the federal government and state and local um, spaces. You're going to be working with individuals who are going to be supporting your company, and or you're going to be talking to other companies who might be your subcontractor or teaming partner. And you want to make sure that the information you give is only relevant, to the work that they're doing for that particular project. Because, today they could be your subcontractor or teaming partner, and then tomorrow you're competitive. Or at the same time, as businesses, you're constantly meeting people and talking about your business, but you want to keep that to a minimum, only as a need to know. And this presentation is going to teach you about how to use non-disclosure agreements and what it means to your organization to have them in place, and how to keep them up to date and make sure you keep going. And even if you've been a subcontractor or teamed with larger companies, you most likely have signed the NDA before you've disclosed any information about your firm. Okay, so that's what a non-disclosure agreement is. It's an agreement between you and another company. So let's see exactly what the definition is here. ANDA is a legally enforceable contract which creates a confidential relationship between a person or a company who holds some kind of trade secret and a person to whom the secret will be disclosed. Okay. Um, in my career, a lot of companies, even the company that, I've worked in, we would even give non-disclosure agreements to our employees. If you think about it, those individuals are representing your company and they're working on your contracts or your work, and you want to make sure that they understand that this is your company's proprietary information, that, and as an employee, that would also, damage the company if they were to go out and disclose those things to anybody, any and everybody out there. So a lot of companies have done that when they bring people on, they have them sign confidential agreements. The NDAs are sometimes called a proprietary agreement, okay? So that's how you define an NDA. Confidentiality agreements typically serve three key functions. The first is NDAs protect sensitive information. By signing an NDA, participants promise not to divulge or release information shared with them by other people involved. If the information is leaked, the injured person can claim breach of contract. Okay. And especially for those of you who are brand new companies coming out, this is very important, that when you start establishing your company and working, you need to make sure that when you're giving people, even, like I said, work in your company or talking to new people to do work with, okay? Make sure that they're signing an NDA first, okay, before you have that conversation. And when you're out marketing and you're doing business, make sure that those conversations only talk about the capability or what is available online or on your CAPE statement, capability statement, meaning CAPE statement, or your other company advertisements, general information, anything about your clients and inner workings of your contracts and things like that should be only disclosed after you've signed an NDA with people, okay? And so to avoid your company from getting into those pitfalls where you have to go to court to, um, you know, sue somebody for damages that may have caused by disclosing things without your permission, okay? So think about that when you start hiring people, they should do it. And when you're doing business with the government, um, not so much the government people because you want them to know that, but I'm talking about people who you are teaming with. And that's why we add teaming to this presentation because they're directly related to one another. The second point is in the case of new products or concept developments, and a confidentiality agreement needs to be in place then, okay? Um, some of you are developing things, new products. I worked with a lot of people during the COVID time where they were developing things to fight COVID, the tests and all of that. And if they were engaging other folks to help them with that, they had to sign NDAs, okay? It's a competitive world out there. And you want to make sure you protect the things that you're going to be developing, just as your competitors are going to be protecting their information. So if you're going to play in this area, make sure you're protecting your company. It's going to save you money down the line and the time that's spent with litigation trying to resolve something that leaked out of your company that you want to get reparations for, okay? In many cases, public disclosure of a new invention can void patent rights. Properly drafted NDA can help the original creator hold on to the rights to a product or idea. I know I talk to a lot of people who come to me who have a new product or that they're thinking of selling to the government, and they too will be having people come aboard to work with or talking to people who might help them with that. So they're going to be needing these agreements to protect themselves. Okay. Point three, NDAs expressly outline what information is private and what's fair game. In many cases, the agreement serves as a document that classifies exclusive and confidential information. Time periods are also commonly addressed in NDAs and usually require that the party receiving the information stays mum for a number of years. This specific information is usually up for negotiation. And you'll see as you start utilizing NDAs, you know, the language there should include the number of years that you would like that individual to make sure they don't talk about your company's information to anyone. Okay, so like when they say it's negotiable, it is. I've been a contract administrator, and part of my job duties as a contract administrator is to be the individual in different organizations to make sure that they're covering themselves with the NDAs. Okay, so we decide both the prime company that's talking to a subcontractor or potential employee or whoever, like how long are we gonna uh, have them hold on to that information? So, like we say, it's usually 2 to 3 years, sometimes more, depending on, the sensitivity of the products or services that you're going to be talking about. Okay, um, I know in the federal contracting realm, we when we're looking for teaming partners, for instance, we could talk to a number of individuals and then try to decide on just one partner, right? So each and every company that you interview and talk to about that requirement that you're bidding on needs to sign an NDA. And, as a contract administrator, we keep up with each NDA, the date it was signed, and how long it will be in effect. Okay. So that's something that should be done each and every time. And you need to tell new employees as they come in, when they're out there representing the company and talking, that they let the corporate office know so that people like the contract administrator can get involved and prepare that NDA for that specific requirement that you're going after or going to be talking about with outside individuals. Other cases in which confidential information might be protected through an NDA include the following: any new business ventures, or people that you might be talking to for funding, or some joint ventures that you're working with other companies or individuals. Then you need to sign NDAs. Any plans for new tools to be produced by fabrication shops, excuse me. Information about clients or customers for a specific company. Okay. Let's say if you're working, in a medical field, and you're have people who are doing lab tests and helping out. That's business that you can do with the government too. Healthcare services. Then about the HIPAA rules, not disclosing information about people's health issues or health concerns. That's even sensitive down to family members. Sometimes you need to designate specific people that could have access to your results. So by all means, if you're working in an environment, all your employees need to have an NDA so that they don't disclose test results or other private information about their patients. Okay. Okay. Um, Embar- Embargoed news releases or reviews can't be disclosed. Okay. Prior to entering into a working arrangements or a business venture, or mainly what we're talking about here, because PTAC's involved in the federal contract and state and local areas, you really do need to start that out before you sit down to the table and talk. An NDA, all right? NDAs, again, become a part of that whole agreement. Let's say you get involved with the company, you bid together, you win that contract, so you're going to be issuing a subcontract. That final subcontract is going to reference that initial NDA signed, and it carries over. In fact, language about confidential information is put in each of those documents as you go through that process of bidding. And when you become a subcontractor, that becomes a part of the subcontract as well. NDAs are an almost surefire way to confirm that confidential information stays protected in a variety of situations. It's important to be aware how these legal agreements work before signing or creating a document, as being well informed can help you make the best legal decisions now and down the road. This goes two ways because, in any instance, your company can be the prime contractor who's giving that information out and sending that NDA to your potential partners. And you could also be the subcontractor or the second party that's receiving that NDA. So on both, the prime usually is the developer of that NDA, and the subcontractors are the receivers who need to thoroughly read that agreement to make sure you are in agreement with those terms and conditions prior to signing. Okay. You know, as we meet new people, a lot of companies have their way of doing things, and you have yours. So a lot of times they will read your document and decide, well, I don't like this phrase, I want to change it, you know. And as long as legally it's okay, and as long as it doesn't decrease the protection you have for having that NDA in the first place, then sometimes it can be negotiated. Okay. And NDAs, you know, just make sure that, that person's on your team, that, they won't use that against you by, spilling the beans to other people they talk to who might use it against you, or, decrease your chances of being competitive on another bid because they have that information about you. Okay. It also could protect, uh, people taking your idea. You could have somebody working on a project for you, and then they take your hard work and time you put in creating this newly proposed solution for an agency, take it and run with it and tweak it and start a whole new thing. Okay. Unfortunately, we have to be that way in today's world. We need to protect ourselves. Okay. And that's a part of being in business. So you've started with the NDA, and then you pick the best company or individual to hire to help do certain things within that new venture that you're making, or that proposal you're working on for work within the federal, state, and government agencies. And so now you're going to do a teaming agreement, okay? After you've decided, yeah, I picked ABC organization to be my partner here, or I'm hiring Joe Blow to be my employee to work on this contract. Okay. Um, you need to develop a teaming agreement. Now, for employees, we don't go as far as saying teaming agreements to do a teaming agreement for them because they become an employee. So we just use the teaming agreement, the NDA, and have that in their personnel file. But companies and consultants need to, you know, uh, be you need to make sure that you have these two documents in place prior to, while you're working on that proposal. Okay. Um, we've had people, throughout my career in federal contracting who sometimes want to bid with more than one company at the same time to increase their chances of getting work. Okay. And so you run the risk by not having these documents in place of, some of your information being leaked out or shared with other companies. And a lot of times, some of the language in these agreements will forbid the other party in, of course, sharing that information with the NDA, but also teaming with other companies. Okay. All right. Because, I can't repeat it enough. The person you're talking to today can be in another instance, another contract, or another agency, or even within the same agency, can become your competitor. So it's really sensitive, and you need to make sure that they understand that and that your company is following all the right protocols. So what is a teaming agreement? A teaming agreement is a contract between two or more parties, and we can relate to them as team members, okay, that used that this teaming agreement is used to regulate the rights and obligations for one of the parties pursues a contract with a third party. Okay. So the prime contractor is the person pursuing the new contract or work. And the teaming partners are the companies that you would bring in to help you win that proposal or become a, a, an advantage to help you win that proposal. And some people just, bring other companies on to make the team stronger, or, they can be that missing puzzle in your solution that you're providing to the government. Once a prime contract is entered into between the third party and a team member, a subcontract is executed between the team member, number one, and the other team members to enable team member one to discharge its obligations under the prime contract. Okay. I've worked with, federal, state and government contractors every day, and, especially the new ones that are just starting out. And, they'll say, well, I haven't seen a full blown proposal yet because I haven't, I need that education because I've only had teaming subcontracting um, experience, and I only get to see the portion that or become familiar with the portion that I'm actually writing to or that I'm actually working in. Well, that's fair because again, you're protecting your proprietary information. Um, I do technical proposals, and when we do our reviews, a lot of times if a company has a subcontractor, you know, they aren't participating in the review of the whole proposal, but only in the portion of work that they're being subcontracted. Okay. So keep that in mind. Make sure, you can trust people all you want to, but at the end of the day, you don't know if what they're going to do with your information. So you don't want to make sure that, the solutions you bring to the table, to the government in your writings are protected from the people on the team in such a way. So it's only fair. And, when people ask me that about, you know, how can I, learn how to write a proposal if I've never seen a full-blown proposal? Well, don't be mad at the prime contractors for, keeping that full proposal under wraps and only seen by that companies, the prime contractors company members. Because one day you're working your way to become a prime contractor and you need to be protecting your company the exact same way. Okay. So keep that in mind, that everybody is looking out for themselves in that respect, and you should be. The benefits of teaming agreements: they allow parties to pool resources for a limited purpose, meaning we're going to get together here and provide the best proposal to win this contract, and the subcontractor is going to perform that portion of the work that they have discussed and that they have provided to help that prime contractor win. Okay. So without necessarily requiring the establishment of a joint venture entity, you don't always have to have a joint venture to team together. But a teaming agreement is what marries your company to the prime contractor as a team, a total team. Okay. So, there are various ways, you can team together, and joint venture is one of them. So, that's maybe something that you might want to do. But again, in the initial meetings to talk about these things, these documents need to be signed, and then you can decide how you work together. Okay. Common terminologies, teaming agreements, and some things that should be included we're going to talk about now. Confidentiality. Neither team member may disclose the confidential information of the other. Okay. Dispute resolution. Which jurisdiction laws govern the agreement, and are there any mandatory pre-filing dispute resolution practices such as mediation or arbitration? That goes as a standard in teaming agreements, okay? The prime contractor usually would include in their teaming agreement the laws and location of that company's corporate headquarters, okay, would be the actual place that they would file any uh, grievances or claims. We live in the state of Maryland, for instance. If my corporation is headquartered in Maryland, then we're going to abide by the state of Maryland rules as a prime contractor if anything should need to be legally detested, or any claims made against the prime contractor. Okay. And you will see that dispute resolution in each teaming agreement, or it should be included. And as you review your teaming agreements, make sure that these things are covered so that by signing that document, you're fully protected from these specific areas. Another area is intellectual property. Okay. Like I said earlier, you're bringing that subcontractor or consultant on, to help you craft a solution for, something you're doing for the third party. And so you want to make sure that the intellectual property that you as a subcontractor or you as a prime are sharing with each other. Um, as far as it goes to the government, you need to understand that you're bringing your intellectual property into this teaming agreement with another company to craft a solution for the government. Okay. And as you do that, the prime should not be disclosing it, and you should not be disclosing the prime's information. Okay. So that's very important. And if you are doing work with the government, you understand that when you craft this solution and it's for the government and you're getting paid, even if you're a subcontractor, you're getting paid from the prime to do this work, then that intellectual property for that particular solution you help craft becomes property of the government. However, it is not the property of the prime contractor. It was just a pass through to the federal government. So by the signing that teaming agreement and including these terms, that's going to protect you as a sub, and on a broader level, it's going to protect the prime for the information they're providing as well. Okay, teaming agreements can help with liability. Neither team member is liable to the other in respect of any loss or damage suffered or incurred in respect to any goods, services supplied that's included in an agreement, except to the extent that the loss or damage is caused by resources contributed by one team member that may be infringing any intellectual property rights. Okay. So, people sometimes hate legal terminologies, but this is a document that I think each business owner should read and understand so that, when um, people in their organization ask questions, they can talk about it as it relates to the requirement, and you know make sure that someone in your organization can do that, short of you going out and getting a contracting lawyer who would, you know, review these documents as well. But a contract administrator is a person within your organization that you would either hire as a consultant or as an employee who's going to help protect you from litigations as far as, you know, how that contract's information is going to flow down and who gets it and etc. Leaderships Leadership individuals who controls the contracting process and how the communications are regulated. Okay, they, if the employees are going to be privy to that information overall. Again, as I mentioned, it's important that even your HR people make sure people sign confidentiality agreements, you know, um, when they're hired, but in your teaming individuals the leaders of the other company who are going to be involved with helping you craft that document and represent the subcontractors that are going to be working on that contract, they need to be um, privy and sign the teaming agreement. If you work for a company that's bidding on a contract and um, they're going to be utilizing your company, a lot of times the company will sign the teaming agreement, but it encompasses everyone who works for that company, okay? Or you may see other times when the company may give individual um, NDAs out, and then they have a overreaching teaming agreement that's going to cover that relationship as you go on with the bidding. Okay. Now, even if you don't win the bid, like we mentioned, the validity of that NDA will still be enforced for a number of years to cover the information that you gave out to the other parties. Management people, a group of representatives from each team member, which we call the teaming committee, usually meets regularly to manage and pursue the contract. In pursuit of the contractor's venture, okay? Non-circumvention. Neither party should submit or participate in independent proposals to the third party, and both parties should act in good faith when discharging their obligations under the agreement. Okay, so we're going to trust each other by signing this document. Okay, and recently I haven't heard of any, many cases where there's a breach of information um, from people teaming together. And I think that it helps deter people from doing anything and protect themselves and the people they're working with by, holding that information and making sure that you're abiding by the rules that are established in these documents, okay? So if there are any parties in relationship, you need to make sure that the relationship between the parties is that of prime contractor and a subcontractor, and not that of a principal and an agent. Okay. So, make sure this is something you're doing together, and that you're gonna be pursuing and in contract, okay? Or and that this teaming agreement is a part of the beginnings. Before you submit that proposal, you're gonna talk to that prime contractor if you're the sub and make sure that um, the work portion that you're gonna be representing, if that contract's one, uh, is included in the documents adequately. So if there are any disagreements or failures, your company is protected because you've signed these documents and you've read them thoroughly to make sure that you're represented correctly, and that any negotiations that need to be done prior to signing these documents are done. And in that document, and once that signature is there, you have become in agreement with those terms and conditions, okay? So just do not be lackadaisical and just assume that, because I signed this particular format and it looks like it's coming from the same company, oh, I'll just sign off on it. Well, you need to make sure that you are, again, in agreement. Somebody should be reviewing it to make sure that it's okay, all right? I know, people who are in the business of building business for the government. You're gonna the business development people, they're constantly looking for work, and so it's gonna be new efforts going. And so you probably should figure, well, I can just get a general NDA in place and keep it in, that'll be okay. Uh, you must know that each and every procurement that you go after is going to be different. You're going to deal with different agencies, different people. So I think it behooves you to have a separate NDA for each effort that you make, okay? So that, any new information for that particular agency or requirement is included in the teaming agreement, and that it is represented correctly and the way both parties, the prime and the sub, agree to. So I know that adds extra work, but it's cheaper to go ahead and do it right the first time than to have to go back and fight some litigation because you neglected to read a document thoroughly, than to get it right the first time and let so that both entities are represented adequately in these teaming agreements. Okay. Resource contributions. What property, human resources, and financial resources are the team members required to provide in order to tender for the prime contract? And does the other team member have a license to use these resources? Okay, think about that. Okay, what are they bringing to the table? Normally, we have in the teaming agreement, you have the first section of the agreement talks about the legalities, and then at the very end, you usually have like an exhibit that describes the situational information that you're going to be providing, the services you're going to be providing to the prime contractor or person initiating the teaming agreement. Okay, so it's good to look at the entire document and especially exhibit, as we call Exhibit A, and maybe some other companies who maybe arranged as a little differently, but it should be included in that agreement where they talk about exactly what that relationship will entail. Okay, so um, keep that in mind. Uh, Termination. What events trigger the right to terminate an agreement, and how much notice, if any, is required? That should become a part of that agreement as well. Okay, because there are times when people get into situations or companies get into the situation where, you know, you are forced to have to terminate the agreement because of some other kind of breach. The government may decide that the subcontractor is not performing adequately. How does the prime legally terminate that agreement? Okay, this should be outlined in the teaming agreement as well. How many days do you need to of notice you need to give the prime contractor or vice versa of that ending of that relationship, and how it should be communicated. Normally, you have so many days to inform the prime contractor or the subcontractor informing the prime contractor of their wanting to terminate the agreement, and also the language used in that. Okay, so you will see language there about what triggers a right to terminate under these agreements. One limitation with teaming agreements is that they need to be renegotiated. They may need to be renegotiated for every new prime contract, what I just said earlier. And I'm thinking it's to your best interest to make sure that, you look at each and every teaming agreement. Okay. Very important. There are also the risks that one member will go around or circumvent the other team member in order to contract directly with the third party, or that one team member will solicit clients or employees of the other. Okay. So, that's a real risk. And usually in every teaming agreement, I know in the teaming agreements that I produce for my clients and my company, you know, you can't just go and, hey, say, wow, I like the way, you know, John works at that company. I sure would like to put him on my team, and go and have a side conversation with John and say, hey, John, come on over to my company and team with me instead of staying with this team. This document protects you as a prime contractor from that happening, okay? That, when you interview people and you sign that NDA and talk to people or companies you want to do business with, that you feel secure that they won't try to circumvent the rules and regulations. So this document being in place, as I said earlier, will help to deter people from treating you that way. And, you know, and I have to say that if anything like that happens, you should never do business with a company again, because integrity is very important in our business workings. And that's a part of it. And teaming can foster more business for each company, where you can team together. Um, hey, as long as you're in business, you know, you're gonna have situations where one company maybe have more expertise than the other, and you can decide who's gonna prime, who's gonna sub. But make sure your documents are signed for each requirement so that you're covered. Okay. You might be friends today, but you don't know what's going to happen down the line. That could cause um, you to say, "Oh, wow, I need to rethink this relationship." So again, you can have a way if you want to end it. You can, like I mentioned earlier, with the teaming agreement. The termination portion of the agreement, and ways to prevent them from trying to circumvent the information that they've already signed up for in this agreement, and still go out and give out company secrets, or um, not hold um, true the information that they've agreed to in these documents. All right. The teaming agreement in place is a clear circumvention to keep them from going after things that would be contrary to the agreement they've already signed with you. That's what this language is talking about. Okay. And that's so important. Okay. Especially when you're going to be dealing with other companies and information is going to be exchanged. Okay. That people feel relaxed and at ease because those documents are in place, that I have a leg to stand on should you um, divulge my company secrets or my solutions that I talk about with potential teaming partners. Anybody have any questions so far?
Hi, Arlene. We just had a couple of questions regarding if you're going to provide samples of the teaming agreement and NDA, and I told them that there will be samples in the packet that I'm going to email them after the webinar.
Great, you sure will. So definitely. Thanks, Yasmin. Okay, so I know that the title says NDAs and TAs, but I like to tell people the whole relationship between the two, and also how it relates to forming that subcontracting agreement, because that's the combination of that whole NDA journey. Okay, at the end, you're looking to win that teaming effort under a certain requirement and be awarded a contract where you would then give your teaming partners a subcontract document. Okay. Another document that includes legalities of how this relationship will work after the contract is won. And again, each entity should know what's in that document and agree on it prior to signing the subcontract document. Okay. And the information is going to flow. It'll include information from the NDA, again, making the non-disclosure of confidential information or proprietary information being released to other individuals outside of that teaming group or relationship. And it's going to flow up to the teaming agreement, and then put in the subcontract, or at least reference those documents as being a part of the subcontract agreement. Okay. We've come to the end of our presentation now, and if anybody has any final questions, let's talk about it now. As I just discussed with Yasser, we're going to provide a sample TA for you to look at. And the things that I've just covered are actual clauses that you will see in or should be seeing in your NDAs and TAs, okay? Again, the subcontract document is the final document that you would sign when you begin working on that contract, okay, with other companies, okay? And it can be done for consulting companies as well who might be helping you out to perform work under contracts that you become involved in. Okay. Yasmin asks if there's any other final
Yeah, sure.
questions.
Okay, yeah, we have a couple of questions that have come in. First question is, in my experience, the prime asked me to sign the NDA and the TA. Should I also have the prime sign my NDA and TA?
Yes, because in most cases you're exchanging information. Okay. The prime is telling you about the work that they want you to help them with on their uh, venture or contract that they're going to work on. And you're telling them about your expertise that you're providing to the table to help them win. Okay. Again, um, hey, on each side, you have things that could all tear it apart if other entities were aware. It's all about being in competition with everybody else out there, and in this GovCon area is a very competitive area, and you want to make sure you're protecting your efforts in that, especially your plans on how you're going to operate on a certain contract aren't shared with other companies who could be in competition with you. So no, yes, both entities should sign. Usually it's one document, people feel comfortable if you're the sub and you sign the primes. Or you could request that, individually you have your own documents and you both keep separate documents. Okay. So it's up to the entities, but please do protect yourself that way.
Okay, great. What happens when a company is working under a prime as a sub and the prime terminates? How can the subcontractor protect themselves?
Well, you have the right, they have the right to terminate for various reasons, and those are labeled or talked about in the actual teaming agreement, okay? So if it turns out that uh, you're not performing well, or um as far as the subcontract is concerned, let's say the prime's not paying you the way you want it to be paid, or these subcontractors claim to have had experience where they're not demonstrating once they start performing, and that prime feels that sub needs to, be changed, or the government requests it because the government feels that the subcontractor is not pulling their share of work or doing excellent work, or upholding their part of that particular contract, then you the prime is in right in terminating that teaming agreement with that prime, that subcontractor. Okay, so you know it goes both ways. Both entities can terminate each other, and overall overreaching is how well are we supporting the government, the third individual, the supporting that relationship between the prime and the government. And as a subcontractor, you need to hold up your end of the bargain. That if, let's say, you feel you've been mistreated, again, because you have a signed document, you have a legal right to, you know, contest that and kind of understand why you've been terminated from this particular arrangement when you were doing it. But again, one of the privileges of being a prime is that you get to choose who your team and partners are. So if you feel that you've been unfair, it's been unfair, then you do have a leg to take it to court if you choose so. But again, do it right the first time. Going to court is expensive. You know, small, medium-sized companies, sometimes you have to decide what battles to fight, okay? And if it really didn't cause your company that much damage, you need to walk away in peace and hope that you can still use that company for past performance. Because one of the things you're coming together for on a contract for is to gain past performance by working with the larger primes or even equal primes. Two small businesses can come together and you can still gain experience in certain areas if they give you positions under that contract as a subcontractor. So, just think good about it. Think clearly about it. You might need to get some legal advice from individuals they have federal contracting law or lawyers out there who can discuss certain situations with you and give you more insight on, how you should respond. So, the idea is to prevent it from going to the lawyers in the first place by having clear-cut agreements, making sure it includes everything that you feel would be right for your company performing as a subcontractor and vice versa for the prime. Okay, I hope I answered your question correctly, but because these things can be kind of wide. There are many, many possibilities out there, but just make sure that your agreement is very tight and, the prime will always have a way of terminating, especially if the government's saying, this contract is not doing what it should be doing, or there's a personality disagreement. Normally that's just taken with changing the person, but, you hope that it doesn't go down all the way down to the subcontracting area. And, and as a subcontractor, you should be not trying to market to the prime contractor's client that you may be working for as a subcontractor, and be a subcontractor because that's the role you're being engaged for. So, just look at, your impact on why it came to termination in the first place and discern whether it's something worth fighting for and if the money involved in doing that fight is worthwhile. Okay?
Okay, thank you, Arlene. That's all we have time for today. So I don't know if you want to, do you have your contact information there if anybody wants to follow up?
Yeah, here we go. Yes.
Okay. Do you want to tell them briefly about the consultation?
Yes, I will. Thank you guys for joining us today. And like I said, my company, we provide contract administration services, and I've done it for years in my long career. And here's my contact information. We offer a free 15-minute consultation if anybody has any questions resulting from this presentation. And, that if I can do anything within that 15 minutes, it's free. And if you, decide you want to engage us, that's can be discussed. So this is my contact information here, keep it handy, and, do go to our website and check us out. Websites there, and our LinkedIn, and the calendar that you could sign up to actually talk with me. Okay. So thank you guys for joining us.
Thank you, Arlene, for a great presentation. Thank you, everybody, for your questions. Hopefully we got to most of them. I know we can't always get to everybody. But if you hang around with the Apex long enough, you'll see that we repeat a lot of our classes. So you'll have other opportunities to address issues. And of course, don't forget to contact your Apex Accelerator counselor, because they are well versed on a wide variety of procurement topics and can assist you. So thanks again, Arlene. Thanks, everybody. Bye-bye.
All right. Thank you. Bye-bye.